Court is now open. You may be seated.
Mr. Foyer. You may proceed.
Good morning, Your Honors. I'm here today with my partner, Lee Goldstein, and we are representing, I hope you'll excuse me, I have a very bad cold.
That's fine.
I'm here representing the plaintiff in this case, the plaintiff appellant, Gail Nelson. In the summer of 1995, Gail Nelson was a 44-year-old woman working as a secretary for Salem State College at an off-campus building. The building was a shoebox-shaped building, and there is a picture of the inside of the building, excuse me, on page 25 of the volume 2 of the appendix. That's taken from the videotape that was made there. It was a shoebox-shaped building. There were two floors to it. There was a ground level floor, a street level floor, and there was a basement floor that could not be seen from the street. The front of the building had a glass window and a glass door, and then about halfway back there was a 5 to 6 foot partition. Behind that there was another 5 to 6 foot partition, which, by the way, the trial court judge does not mention, that there are two partitions there. There's a third partition which blocks off the stairs going downstairs. Ms. Nelson was the person who was in charge of the upstairs area. There were lots of activities going on in the center there, in the downstairs area. But there were times when Ms. Nelson was alone in the center. She had a key to the center. She would come in during the summertime. Sometimes she would come in early. Sometimes she would stay late. And the director of the center, her boss, Fred Young, knew that she stayed late and came in early, and that she would change her clothes in the back of the center, behind the partitions with the door locked, not accessible to the public, not open, sometimes changing it out of her street clothes into work clothes and vice versa at the end of the day. During that summer, Ms. Nelson also...
Can I ask you, are there any bathrooms in this place?
There is a bathroom in the downstairs. Ms. Nelson has a number of physical problems that made it very difficult for her to go downstairs.
Is that in the record? Is that in the record what her physical problems are?
No. What is in
So
the
how do
record
we
is
know?
her statement that she did not use the downstairs bathroom because of physical problems. It does not list what those problems are.
So we don't know. Physical problems could be physical problems in the plant, in the structure of the building.
No. She talks about her physical problems. She doesn't delineate what they are.
So the evidence is that she changes in this office, even though there are no offices here. This is all just some partitions and open to the street.
Well, it's not open to the street.
Well, I'm looking at the picture.
That's exactly the point.
All right.
The testimony from the police chief and the testimony from Officer Fuller, who put the camera in, both of them testified that you could not see behind the partitions in the office there from the street or from the front of the office. That's on page 63 and 64 of the appendix, volume 2, and pages 117 to 118.
But at least some of the time when she was applying the anti-sunburn ointment, someone could have come in the unlocked door, an employee, say, could have come in and walked through and just gone to the rear.
Could have. However, Ms. Nelson was responsible for locking the door during the midday. The center, she was on break. As part of her union contract, she had not only the right, but she had the responsibility to close the center during that lunch hour and lock the door.
There are 3 programs in that building,
Correct.
right? And how many people have keys? 9?
9.
All right. So she's not the only person who's got a key to
She's
there.
not the only person.
And in fact, this is open almost all day long, public, and people come in and do business here.
During the day,
Yeah.
during regular business hours. Not before regular business hours when she was changing the clothes, not after regular business hours when she was changing her clothes. Obviously, she would not change her clothes on a night when there was a meeting scheduled. She would know that. She changed her clothes when there was nobody expected in that center.
But even so, even if it were after hours, as Justice Cordy mentioned, other employees had keys.
That's correct.
And she was aware of that.
And the cases say that when you have a reasonable expectation of privacy, that does not mean you have exclusive control or dominion over a particular area.
Mr. Foyer, what was the profit reason for the video surveillance?
The reason offered by the college was that they suspected that there was some unauthorized entry into the building after hours. That's exactly what they said. That's the only thing.
Yeah, there was someone, as I understand it, who was being investigated criminally and who was barred from coming into these offices. And one of the merchants across the street said that he had seen that person actually, with a key, entering the office to meet with your client.
That's correct.
One night.
That's correct.
Which had been prohibited. And
No,
so the issue...
They did not say they saw a meeting with my client. And in fact, the testimony is on page 20 of Appendix 2. The testimony is that the Fred Young was who's the director of the center, did not instruct the police to focus their investigation on Gail Nelson or Wayne Koss, who was the man they suspected of coming in, or anyone else. He testified to that.
Understood, but the reason that they began the investigation was because they had evidence that this Mr. Goss, who was under criminal investigation and who had been barred from these offices, had in fact been getting access to them.
They didn't know who it was. They were told, Mr. Young told the police that we want to investigate unauthorized activity in the center after hours.
Can we back up a little bit? But what wasn't Mr. Young told by the store owner that he had seen Mr. Goss entering with the plaintiff?
No. He was told that he saw him entering and he thought he had a key. That's what he was told. Gail Nelson was never the target of the investigation, and I would refer you to Police Chief Prey's testimony on pages 76 and 77 and 78 of Appendix 2. He was never told to focus his investigation on Gail Nelson.
No, but weren't there reports that she was meeting in the office with him on at least one occasion? When he came in, they were seen together.
He had been a client of the center before he had been banned. So, yes, she had met with him.
No. Correct me, please, if I'm wrong. Was there at least one report that she had met with him, was seen with him in the office after hours?
No. I don't believe that's in the record anywhere.
Mr. Foyer, if we decide this case on the qualified immunity question and rule that there is qualified immunity, we don't have to reach what I take it as the gist of your argument now, namely her expectation of privacy.
I believe you do, Your Honor.
I nevertheless have to reach it?
I'm sorry?
If we decide the qualified immunity issue against you, in other words, in favor of the state officials, we don't have to reach the constitutional issues, correct?
I believe that you do have to reach that question.
Tell me why.
The Supreme Court and the First Circuit both have said that it is a two-step analysis.
No, I understand. Their preferences that you reach the constitutional question first, correct?
Well, I don't know. I don't believe that it is a preference. I believe it is a command from the Supreme Court. Even in the case cited by my brother, in that case they did look at the reasonable expectation of privacy and whether a search had occurred. That question has to be answered before you can answer the second part of the qualified immunity test, which is, was this right clearly established?
Aren't the two questions intertwined, though? I mean, that's why I don't understand the proposition that you have to do one and then you have to do the other. It seems to me that you have to first tell if there's a constitutional right. And if you're having a great deal of difficulty establishing whether there's a constitutional right, well, then you say, okay, it clearly wasn't clearly established. And if you say, oh, it's so easy, I know there's a constitutional right, then you'll move on to whether it was clearly established. But I don't understand the distinction that you must do one and then the other.
I think they are intertwined. But the point is that if you look at the constitutional right first, that helps to inform the question of whether it's clearly established. Because you need to know what the contours of that right are. You need to know whether or not the facts in this situation fit the contours of the constitutional right.
How would you describe the constitutional right?
In this case, I believe the constitutional right was to be free from an unreasonable search, and unreasonable being defined by a 24-hour, 7-day-a-week, 2-month-long video surveillance.
And does that apply in any workplace? So any unknown video surveillance in any workplace over an extended period of time is a constitutional violation?
It depends upon what it's doing and where it's aimed and the facts of the situation. You certainly have to look at the facts of the situation. Had
Well, I
the
just
police...
asked you to define the constitutional right, and you didn't say it depended on anything. You said the constitutional right is where you have 24-hour video surveillance over a 2-month period of time in the workplace.
Where it is, where you are focusing on or videotaping the private activities of employees. I should have added
How does the
that.
employer know that an employee is going to engage in private activities?
Well, in this case, we have evidence that Fred Young did know that. That's in Ms. Nelson's answers to interrogatories. It's in her deposition. He did know that she changed clothes there. He saw her bring clothes in. He saw her change, not changing, but have different clothes on from the day and into the night when she
the
was leaving.
activity would have to be obviously a legal activity, like changing clothes.
Correct.
I mean, if an employer had a suspicion that employees were going into the restrooms and
Smoking
taking
marijuana.
drugs, they could mount such a surveillance because that's an illegal activity.
Well, the question there is whether or not they would need a warrant to
Well,
do
the
that.
question there is, in a bathroom, one can assume that there will be private conduct by people who may not be the targets of the surveillance, correct?
Exactly.
And my question is it an actual knowledge? I actually know that in this office, at night, before work, I'm going out for a jog, I know that this employee, changes clothes?
No, it's an objective standard. You have to look at the circumstances and see, is there a reasonable expectation of privacy in this area?
Well, why do you say
And-
that the judge was wrong in saying that in 1995 there was not a clearly established right to be free of this type of search?
Well, there's two things. First of all, the judge focused solely on the place and the characteristics of the office. As we all know from the Katz case from the Supreme Court, the Fourth Amendment protects people, not places. In
But what's the
1970...
there's no difference in the reasonable expectation of privacy.
Yes,
right?
there is, Your Honor.
Why?
Because, as the Supreme Court said in 79 in Bell versus Wolfish, there are 4 factors you have to look at. The scope of the intrusion, and video surveillance is a different kind of intrusion than a police officer walking into an office. You have to look at the manner in which it is conducted. You have to look at the justification, and you have to look at the place in which it is conducted.
Because the
What
place
I was-
is relevant to whether...
It is one of the 4 factors.
is relevant to whether your expectation of privacy is reasonable,
Absolutely.
objectively.
Absolutely.
And certainly the court has said in public buildings where the public is invited, where they come, where lots of people, things are going on, that expectation, that's an important factor in whether or not one could have an expectation of privacy.
That is correct. However, that doesn't mean that a public building never has areas of privacy in it or never has times of privacy.
That's true.
As the Takeda court said,
Locked file cabinets, for example, the Supreme Court says, well, there,
that's correct. And the Takeda court says in somebody else's office, you may not have a personal expectation of privacy against somebody else walking in there, but you would have an expectation of privacy against being videotaped by the unblinking eye of the camera.
Mr. Foyer, what I'm saying to you is that the facts about whether or not employees have a reasonable expectation of privacy really is no different 10 years ago than it is today. In other words, do employees have a reasonable expectation of privacy either in their own offices or in some space which is not specific to them?
I think
Don't I have to get over that question first? That's why I said if it's actual knowledge, which the employer has not prohibited, that may be the case. But you're saying, no, it's, there's a broader issue here.
I think video surveillance is the issue here. And in 1995, there were no cases, other than one not cited by the trial judge, there were no cases that said that this was all right. There were only cases that said there was a reasonable expectation of privacy. The Seventh Circuit, the Ninth Circuit, the Second Circuit, the Fifth Circuit all said there's a reasonable expectation of privacy against being videotaped. The state of Hawaii in their highest court and the state of Indiana said that in their highest court. The cases cited by the judge in her decision were all from 1996 and later. Not a single one was cited for 1995 and before that. There was a clear consensus.
It was clear that you could not videotape an open space in a public building?
No. There was a clear, reasonable expectation of privacy against being secretly videotaped under certain circumstances.
That's under certain circumstances,
that's
of
right.
course. And this circumstance is
that
an open building, an open floor, accessible to the public in a public building.
But that included, in the state cases, Bunnell and Thomas, and in the Takeda case as well, those were also public areas.
Doesn't the fact that we're having this discussion in such detail and with apparently reasonable assumptions or citations on each side indicate that it wasn't clearly established?
I don't believe so, Your Honor. And if you look at the application for covert video surveillance filled out by the state, which is page 263 of Volume 1, they knew it raised Fourth Amendment issues. They knew that that was a problem. That the application for covert video surveillance says, I hereby state and affirm the area to be videoed is a public area or an area that the public has a right of access to, and such surveillance is in accordance with state and local laws and does not violate any provisions of the Fourth Amendment.
Why isn't that reasonable? Why isn't that exactly right?
Because it's not a subjective standard, it's an objective standard. It's not what the police officer believed. It's an objective standard as to whether or not it, in fact, there was a reasonable expectation of privacy for the employee.
Right.
Not that the police officer believed that. Now, he said that. Chief Prey, who approved this, testified he never went down and looked at the office, never went down and saw where the camera was placed, never went down and saw what the videotape was showing. How could he say this was a public area without having seen the building?
My guess is it was described to him.
It may have been.
By the supervisor.
Well, and this is a summary judgment standard where the facts need to be taken in the light most favorable to the plaintiff.
Well, we know where the camera was placed. We have a picture. This is a picture from the camera, right?
Right.
This is an open floor looking out onto the street.
The police chief did not see that for 3 months. And
so what's the point?
It does not look out onto the street. The camera is placed way up high.
I can see the street.
Yes.
Through the front windows.
But
that's all open windows.
That's a vantage point that no human being could see. The camera was placed way up high.
Aimed at the front door to see who would come in and out.
And videotaping the entire
and you
office.
Can, because of the location,
right.
You can see the open floor.
If the camera had been placed right at the front door, videotaping the front door, we would not be here today.
Mr. Foyer, your time is up. Is there a closing sentence that you would like to make?
I believe that you have to reach the issue of whether there's a reasonable expectation of privacy with regard to secret videotaping here. If there is, I believe that was clearly established both under Massachusetts law, Commonwealth versus Blood, and the preamble to the wiretap statute, which I would refer you to concerning electronic surveillance, that it was clearly established. I believe also that the judge below did not look at the facts in the light most favorable to the plaintiff. She left out a number of facts that are listed in my brief, and I would ask that you send this back for trial.
Thank you, Mr.
Thank
Foyer.
you.
Mr. Callaghan?
May it please the Court. David Kerrigan, Assistant Attorney General for the State Defendants. Qualified immunity applies to the Section 1983 claim brought against the defendants when, as of 1995, there was no case holding there was a per se rule that the use of secret videotaping was a search or a per se search. As a result, the various factors to be considered by the public officials here, the college police officers and others, required a balancing. That was, did the plaintiff have a possessory right in the premises? Did she have exclusive access to it? Did others have access to it? And also the nature of the intrusion by the Commonwealth. Those factors requires a balancing. And it is the Court's view that when there is a balancing of factors such as that qualified immunity is particularly appropriate. So it is here. This case is no exception to that rule, and the Court's summary judgment finding should be affirmed.
Well, I take it, as I read the judge's ruling, that she is, for purposes of the summary judgment motion, assuming that the plaintiff had a subject expectation of privacy in the office, correct?
Yes.
I mean, that's what she says.
Yes.
So whether or not, as a factual matter, she did or she didn't, the judge is assuming that she did.
Correct.
So, in fact, she's giving the fullest possible benefit to the plaintiff on that factual issue. Am I correct?
Absolutely. Absolutely. As did we in approaching the argument and here, below and here.
So then
we are making that assumption that she did have a subjective.
So all of the factual details which Mr. Foyer has laid out, which would be important, very important, if there was not that assumption, assuming that we can then, move to the other legal arguments we don't have to reach, but if we in turn decide that you have to go back and, what are the circumstances in which I have to factually decide that issue?
That issue, I don't think there are any, Your Honor, because then the next question is this an expectation that society recognizes as reasonable? That issue is a question of law for the Court to decide and ought to decide. And here is where we part company.
Let me put it this way. Her framing of the question, the trial judge's framing of the question is whether, in 1995, it was clearly established that the covert videotaping conducted by the defendant infringed an expectation of privacy that society was prepared to consider reasonable, correct?
Correct. Correct. And I think that is the issue before the Court. That is the correct issue. And looking at the state of the law in 1995, it was not clearly established. There was no legal norm. There was no consensus of authority on that issue. There was a Supreme Court case, O'Connor versus Ortega, that basically said you look at these on a case-by-case basis, and there may be some areas in a public workplace that are private, and there may be others that are so open to the public that are not.
Okay, so your position is we only go to the first phrase, whether it was clearly established. So we don't even have to get to the videotaping conducted by the defendant infringed an expectation of privacy that society was prepared to consider reasonable. In other words, we don't have to get to that. From your point of view, all we have to look at is, was it clearly established?
Well, that's...
But you have to know what it is
before
you can decide whether it's clearly established.
It is that the expectation was reasonable.
Correct. That society recognizes as reasonable. And the state of the law, there certainly was no case in Massachusetts.
What I'm saying to you is that if there's no case addressing the issue seems to arise because this is video surveillance, correct? And essentially, as I understand, there were no cases discussing video surveillance, correct?
In the Supreme Court, United States Supreme Court, correct. The First Circuit, the Massachusetts, this Court. So the cases relied on by the plaintiff are two state court opinions and a Ninth Circuit opinion, which predated 1995, which we think are distinguishable. They are situations where, in Takeda, where there were only 2 or 3 offices with DEA agents who had extremely limited access to them, where there was a video surveillance. And there was a case in Indiana where it was a licensee of a store And the court placed great weight on the intrusion into the store where the person had a superior possessory interest than any of the state people who came into the store.
But what do you do with the fact that the videotape here was aimed, as I understand it, at after-hours activity, when a normal person, reasonable person, would expect that, you know, there's no public access, and I'm here alone, I'm doing my own work, I'm going to close up myself?
A few responses to that, Your Honor. First of all, that is precisely the time when the person had been seen, and it was Wayne Koss who had been seen.
No, but you're
entering.
looking at it from the employee's point of view.
Yeah.
Well, there were so many other employees who had keys, who might come back because they forgot something, who might come back because they wanted
This
to.
camera was running constantly,
Correct.
wasn't it?
It was.
Yeah.
It was.
So I'm segmenting out that time where, and saying, putting that in relative perspective, that's the time you concentrate on, and there would be an expectation of privacy that society would accept.
Well, I disagree with that, Your Honor, due to the number of people that had keys to the premises, number one, who also could use the premises and open the door
But
after
when
hours.
somebody has a key, if I'm in my office and somebody has a key, right, and I am changing my clothes because I want to go jogging, there are endless people who have keys. I shut the door, I lock the door, I hear the key, and I either shout out, "Don't enter, I'm changing my clothes." I don't think that there's a video camera over me.
But I would think that there's an issue, first of all, on the number of people who can enter your space,
Was there evidence
number one.
about how many
And
of these people who had keys were actually coming back after hours?
there was evidence that there were meetings that would occur at night from time to time. There's no evidence in terms of the regularity, other than there were other employees that had keys, who had access to the premises, who could have entered as the plaintiff apparently did. And I also want to point out that the plaintiff had specifically, and I don't think this is highlighted in the brief, been instructed not to be there after hours out of a concern that the college would have to pay overtime for her. So, on the one hand, perhaps...
Yeah, just to interrupt you there. She was instructed not to be there after hours,
Right.
not to work after hours, so that she would request
That's right.
overtime.
Th-
But
that-
to
that's
change
right.
clothes would not be working after hours where she would be charging overtime, would it?
That's right.
Okay.
Nor do I think that there's any evidence that any of the defendants knew that she changed clothes in the open area. There's evidence that they understood that she brought a change of clothes, but I don't think it's quite the line that was drawn by plaintiff, that they knew she would change clothes in the open area.
What's that got to do with it?
Pardon me?
What's that got to do with it?
Well, I want to let the court know that there was none of that.
Okay, so there's no malicious intent, perhaps, but
Right. Right.
factually speaking, on the analysis we're talking about, that's really irrelevant.
Well, I think that
I mean, if the taping's illegal, the taping's illegal, whether they knew she was changing clothes or not.
Here's where it would be relevant, Your Honor, for one of the defenses, the common law defense immunity. Gilday versus Ellershaw, it does require a good faith, no corrupt motive. We think that applies here to the 214-1B claim. Duarte versus Healy specifically recognized that common law immunity does apply to 214-1B claims and intentional tort claims against the individuals. So
It's relevant on that point, I
It is.
understand. Can I ask a question? Were there depositions taken, or was this decided before real discovery took place?
no, there were depositions taken. Your Honor.
All right. I assume, from what I assume that there was no film with the plaintiff dressing.
The state of the evidence was, Your Honor, that no one saw the plaintiff either at all or in any change of undress. I mean, no one said, I recall.
She wasn't on the film,
That's
as far
correct.
as anyone can tell.
That's correct.
All right.
About the
But did that-
sunburn stuff,
No, none of that.
none of that seen?
I thought the evidence was that some of the tapes had been destroyed.
They were reused, Your Honor. Yes.
But,
They were-
but there was deposition testimony, presumably the people that, because these tapes were looked at,
Yes.
by the security people,
Yes.
checked to see if this person was coming in. Were they deposed?
Yes.
Did they say they had seen the plaintiff in some form of undress?
No. No. And that certainly is relevant to the invasion of privacy claim, where
So we don't even know if this camera even picked up any private activity of the plaintiff.
That's right, because part of the analysis for the privacy claim is, does it have to be substantial or serious? First of all, there's no evidence that anyone ever saw anything that she was doing along the lines suggested. There was no evidence that they passed it along, for example. They gathered private information, that they disseminated private information, and in fact, all the evidence was that they didn't see anything that she claims to have been doing in there. So we don't even think it on a merits states the invasion of privacy claim. And as I referenced earlier, we also think that there is the common law immunity that survives post-Tort Claims Act.
I perhaps should have asked Mr. Foyer this, but what is the strongest evidence against the state defendants that there's a factual dispute about whether or not her privacy was in fact invaded? I mean, you're saying there's no evidence that anybody saw anything?
That's right.
Was
Other than
everybody who had access to the tapes deposed?
yes,
And was everybody asked specifically whether or not they had seen?
yes.
Was she asked whether or not she had changed her clothing and put on the sunburn ointment and so on?
Yes.
And is there a way that the video camera could have been recording so that it didn't capture that?
I think, I don't have an answer to that.
Presumably, if she was doing
I
it
think-
at the far end of the office where
Right.
the camera was, it wouldn't have picked it up.
Right,
I
it's-
wasn't asking what the presumption was. I was asking whether there was evidence that there was a way that the video camera. I mean, did anybody ask her where she was standing when she was?
She would say generally behind the last partition on page 25. I don't know if it was as specific in a corner, beneath the wall, that would prohibit it from being seen. I don't think that the record is as clear on that particular point, Your Honor.
Well, would that affect whether she was seen or not? How would that affect whether there's a reasonable expectation of privacy with respect to the secret video?
It doesn't for the constitutional claim, I don't think, Your Honor, because that is an objective.
No, but you're talking about
The
the actual,
statutory
the
claim.
actual
Invasion of
invasion of
Yes,
privacy.
yes. I think it would perhaps be relevant for that claim.
Yeah.
And another thing I'd like to address is there's some, I think, lack of clarity in the discretionary function tests that apply to the various types of immunities. The Section 1983, I don't think I need to address. But, the Gilday versus Ellishaw immunity that's been incorporated into Duarte versus Healy really just I think is more like the 1983 type of discretion, where it concerns, is there discretion in the type of activity? Duarte versus Healy says it's not just policy development, but actually the implementation of that policy. People can be immune from claims. Versus, and sort of contrasted with the 10B discretionary function immunity, this Court has noted that there is sort of a greater requirement. It does require policy planning, financial considerations, matters of public policy. I think I think perhaps the plaintiff has sort of confused the nature of the discretionary acts necessary. And I think that makes sense. You do want a broader immunities for individuals rather than the state, and so the test is narrowed as to the state. But we think that Cena versus Commonwealth covers a 10B immunity for this. That case said the when and how of a police investigation is the type of discretionary functions that the court recognizes under 10B as being immune from a claim.
So your position on the qualified immunity issue is essentially that in 1995 there was no case holding that there was a rule that the use of secret videotaping was per se searched.
Correct.
So that it was not a clearly established right.
That's right. That's right. And in fact, there are other cases that I haven't talked about. Mars versus Marriott Corporation, a state case in Maryland, invasion of privacy claim, not a constitutional claim, but holds that there is no expectation of privacy in an office open to others. So the law even was far from clear. And then just to adopt or for fine for the plaintiffs would require this, really, that you would have to find that as of 1995 there was this clearly established right, even though the law, no Supreme Court case, no SJC case, no First Circuit case. And then the cases, though, subsequent to 1995, the Vega-Rodriguez case in 1997, there's a Thompson case in 1996, there's the McClellan case.
The difficulty, I think, is, as has been noted repeatedly, is the twist with video surveillancing. In other words, and that's why I kept going back to what are the cases about video surveillancing in an office? Because whatever the cases might have to be about locked filing cabinets or who gets access to the door, whether you can barge into somebody's office, are very different, it seems to me. I think there are a fair number of employees who probably think that when they are in a space, even if other people get access to the space, that they have sufficient privacy that they can hear somebody rattling the door. Or they're prepared to take that amount of risk. They may not be prepared to take the amount of risk of a video camera going 24 hours a day.
My response to that would be, Your Honor, that even in video cases in all jurisdictions, they still look at the same type of factors.
No, I understand that.
And then it's
whether that's the best
intrusion.
whether that's the best jurisprudence is neither here nor there because of the, I don't know how much 24-hour video surveillancing was going on in 1995. It's now very easy to do and very inexpensive to do, 24/7.
And perhaps forbidden.
But if there weren't cases involving video surveillance in 1995, then it wasn't clearly established.
Yes, that's the defendant's position.
Isn't that your
Yes.
argument?
Yes, Your Honor.
Thank you.
Thank you.